Welcome to Do It for the Case Law for Thursday, July 9th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today we are covering 57 federal appellate opinions across 9 circuits. The docket features heavy coverage in criminal justice with cases involving drug trafficking, firearms, and sentencing issues. We also have significant civil rights matters including employment discrimination and Section 1983 claims. Constitutional law and habeas corpus filings round out the report alongside immigration appeals, tax disputes, Social Security reviews, and business litigation. Please subscribe to stay updated on future opinions. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. We begin with 24 cases from across the federal courts. The disposition roll-up shows 7 affirmances, 3 dismissals, 1 denial of a motion, 4 reversals, and 2 split outcomes where courts affirmed in part and remanded in part. Leading the docket are 4 major reversals from the 7th Circuit regarding Illinois firearm restrictions under the Second Amendment. The court held that bans on AR-15 rifles and 30-round magazines align with the nation's historical tradition of regulating particularly dangerous weapons, rejecting lower court injunctions against the Protect Illinois Communities Act. Also reversing in the 7th Circuit was a Section 1983 claim where the court found no state-created danger liability for the death of a minor by private violence. Moving to the 9th Circuit, the court affirmed part and remanded part regarding supervised release conditions for an illegal image offense defendant, rejecting arguments that proximity restrictions were unconstitutionally vague. In the 8th Circuit, the court affirmed convictions for drug trafficking and firearms offenses, ruling that expert testimony on general drug practices was admissible under Federal Rule of Evidence 702. The court also affirmed a conviction where a citizen's tip corroborated by a trash pull established probable cause for a search warrant. Additionally, an appeal regarding a traffic stop for an obscured license plate was denied after the court found the detention justified by reasonable suspicion. Over in the 6th Circuit, the court affirmed methamphetamine distribution convictions and a 288-month sentence, upholding warrants based on a minimally sufficient nexus to drug trafficking activities. In the 5th Circuit, we see 2 dismissals under Anders procedures where appointed counsel found no non-frivolous issues for review. The court also affirmed sentences for illegal reentry cases, including one where the government moved for summary affirmance because the defendant's constitutional challenge was foreclosed by Supreme Court precedent in Almendarez-Torres v. United States. A Section 1983 claim was denied in the 5th Circuit as well, where the plaintiff failed to exhaust administrative remedies under the Prison Litigation Reform Act, despite being detained on post-release supervision. The 4th Circuit handled several significant matters. The court affirmed the denial of compassionate release because the defendant's career offender status remained valid based on underlying convictions. In another case, a motion to dismiss an illegal reentry indictment was denied because the non-citizen failed to exhaust administrative remedies before the Board of Immigration Appeals. A civil rights claim regarding prison officials was also denied, where the court found no deliberate indifference to an inmate's safety despite protocol violations. Finally, in the 1st Circuit, the court affirmed the suppression of evidence from a defendant's iPhone, holding that agents did not act with objective good faith under the exclusionary rule despite having a valid warrant. In the 11th Circuit, the court affirmed convictions for illegal image offenses, ruling that Google's hash value matching constituted a valid private search, and that possession and distribution are distinct offenses under the Blockberger test. The court also affirmed a 96-month sentence for a felon in possession of a firearm, rejecting arguments regarding sentencing guidelines errors. Back to you, David.
Thanks, James. Let's turn to Aisha for the Civil Rights Roundup.
Thanks, David. We have 8 cases in this Block 6 affirmed, 1 denied, and 1 split outcome on a rehearing request. Moving to the 10th Circuit, the court affirmed summary judgment for the state of Kansas in Thurman v. Kansas, holding that the plaintiff failed to prove a hostile work environment or retaliation based on gender despite evidence of bullying by a judge. The court also affirmed the denial of post-judgment motions by Van Horn against the Salvation Army, ruling that fraud alleged in state proceedings does not justify relief from a federal judgment under Rule 60b-3. Over in the 5th Circuit, the panel denied Ken Wei-Ji's appeal regarding employment and housing discrimination claims, finding he could not represent the interests of other plaintiffs and that his Fair Housing Act complaint was properly dismissed. The 5th Circuit also denied an en banc rehearing request for Marin Lopez v. Ramirez, a First Amendment case where the dissent argued the mediation order effectively denied qualified immunity at the earliest stage. Finally, in the 6th Circuit, the court affirmed summary judgment for the Department of Veterans Affairs against Latria Harrison because she forfeited her arguments by copying text from her lower court briefs without addressing the specific reasoning used below. In the 7th Circuit, Mace Davis v. Elgin was affirmed on qualified immunity grounds as the court found no precedent clearly establishing that non-lethal impact weapons violated a constitutional right in this context.
The estate of Jason Thompson versus Ben was also affirmed, with the court ruling that police actions regarding medical care were objectively reasonable under the circumstances given the officer's observations of the plaintiff's condition. Back to you, David.
Thanks, Aisha, and rating. Now for Michael on constitutional challenges and habeas corpus.
Thanks, David. 4 cases in this block, 1 reversal and remand, 2 affirmances, and 1 denial. The Sixth Circuit reversed the district court's dismissal of Kyle Millis's federal habeas corpus petition as untimely, holding that equitable tolling under Section 2244 applies because the Michigan Supreme Court's conflicting correspondence created an extraordinary circumstance preventing a timely filing. Over in the Fourth Circuit, the appeal by Ronald Keith Sutherland was dismissed for lack of jurisdiction since the underlying order denying mandamus was not a final or appealable ruling. Also in the Fourth Circuit, the court affirmed the denial of Jonathan Giannoni's writ of coram nobis, finding he failed to show valid reasons for an 8-year delay in attacking his wire fraud convictions. Moving to the Fifth Circuit, the court affirmed summary judgment for Officer Shane Prevet in a civil rights case, ruling on qualified immunity grounds that the right to use deadly force against a suspect with specific characteristics was not clearly established at the time of the incident. Finally, the Ninth Circuit affirmed Moroni Johnson's sentence and supervised release conditions, rejecting his challenge as unright because the restrictions involve contingent future events. Back to you, David.
Thanks, Michael. Next, Maria has the business and civil updates.
Thanks, David. I have 8 cases for you today, covering business, labor, and civil matters across 4 circuits. The disposition roll-up shows 1 reversal and remand, 1 dismissal, and 6 affirmances. Leading with the movement case, the Fourth Circuit vacated a removal order in Maximino Ramos versus Acting Attorney General Todd Blanche. The court held that Ramos's conviction under Virginia Code Section 2111 does not categorically constitute an aggravated felony involving fraud or deceit because the statute criminalizes wrongful taking without requiring intentional misrepresentation as an element. Moving to the Fifth Circuit, the court reversed and remanded in the Juno Group versus Vendera Management Holdings, finding that the plaintiff's request for retroactive reinstatement of a dissolved LLC lacked support under state law and federal rules. In another Fifth Circuit matter, the court dismissed Tomas Ray and others versus LCMC Healthcare Partners for lack of appellate jurisdiction because the plaintiffs failed to demonstrate the severe, irreparable harm required for interlocutory review of an injunction denial. The Fifth Circuit also affirmed 3 routine outcomes: a bankruptcy ruling denying leave to file against a trustee in Ekachukwu Okore versus Kimberly Lentz, a personal injury dismissal in Devon Sneed versus Crown Equipment Corporation, and a premises liability summary judgment in James George versus SI Group and others regarding a tanker accident. Finally, the Seventh Circuit affirmed Nautilus Insurance Company versus B Quality Inc., ruling that a prior work exclusion effectively barred coverage for claims arising before the policy's inception date. In the Eighth Circuit, the court affirmed the dismissal of the Lower Brule Sioux Tribe versus the Department of the Interior, holding that the tribe failed to exhaust mandatory administrative remedies under the Indian Self-Determination and Education Assistance Act before seeking relief in federal court. Back to you, David.
Thanks, Maria. Raj is next with immigration and government law updates from the 11th, 5th, and 9th Circuits.
Thanks, David. 12 cases landed on my desk today. 2 affirmed, 1 dismissed as moot, 8 denied, and 1 vacated and remanded. The major movement came from the Ninth Circuit, where the panel vacated and remanded a case involving ineffective assistance of counsel and granted a petition for review in a separate matter regarding the board's authority to consider post-order IAC claims. In Menjivar Ayala versus Blanche, the court held that the agency abused its discretion by refusing to consider an ineffective assistance claim where prior counsel failed to notify petitioners of the final order and appeal deadline, citing Lee versus Bondi to affirm the board's discretion in such scenarios. The Ninth also vacated and remanded Quinones-Rose versus Blanche regarding cancellation of removal and Convention Against Torture relief after finding the agency's denial of those claims supported by substantial evidence, but leaving open procedural questions on the motion to reopen. Moving to routine outcomes, the Ninth Circuit denied petitions in Jianming He versus Blanche, Martinez Hernandez versus Blanche, Odell Cervantes Marin versus Blanche, Tecun Jimenez versus Blanche, and Tobin Garcia versus Blanche, all based on substantial evidence supporting adverse credibility findings or failure to meet statutory hardship standards. The court also affirmed the Social Security denial in Booz versus Bisignano, finding substantial evidence that the claimant's spine disorder was not severe and that residual functional capacity assessments were correct. Over in the 11th Circuit, the panel denied the petition in Yanis Canales versus United States Attorney General, upholding the board's denial of asylum and withholding of removal by applying the substantial evidence standard to country condition claims regarding domestic violence in Honduras. The Fifth Circuit affirmed the district court in Sanchez Lozano versus Herrera Perez, ruling that returning a child to Mexico would pose a grave risk due to the father's ties to drug cartels and substance abuse issues under the Hague Convention. The Fifth also denied Rivera Carpio versus Blanche for failing to demonstrate a reasonable fear of persecution from gangs in El Salvador, noting his family remained unharmed. Finally, the Fifth dismissed the Texas tuition case as moot after finding federal statute preempts state laws granting in-state rates to illegal aliens while excluding U.S. citizens. Back to you, David.
That wraps up our broadcast for Thursday, July 9th, 2026. Thank you to James Taylor for covering 24 cases on criminal justice, Aisha Johnson for 8 civil rights cases, Michael Reeves for 5 constitutional law opinions, Maria Santos for 8 business and labor matters, and Raj Patel for 12 immigration and government appeals. Today's docket saw 4 reversals, remands or vacators, 30 affirmances, 6 other dispositions, and 17 dismissals. We highlighted the significant reversals and remands throughout the show, while a number of cases were dismissed on procedural grounds. Visit doitfortheCaseLaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe and follow for tomorrow's update.